Jeremy, when it cuts you.
Hello, everybody. This is the Lawyer Show podcast. I'm your lawyer, Jeremy Rosenthal. Do things keep you up in the middle of the night, scare you, intimidate you, make you lose sleep? What is your greatest fear? Don't message us and tell us, or do message us and tell us on Facebook Live. I don't think we'll get anything because probably none of you are watching on Facebook Live. But if you are, then put it in your message what it is. Keep it PG-13. That's what this show is. I think a lot of people's biggest fears is the topic of our podcast today. Today I have attorney extraordinaire Ryan Kreck, who works at America's favorite criminal defense law firm, Rosenthal, Calvis, and Terrian. And Ryan Kreck handles CPS cases. He handles what happens when you get the knock on the door or the phone call from a CPS investigator or somebody who says you are not parenting your children well enough, and that can be a pretty scary deal. So my co-counsel today, I will have him introduce himself. Ladies and gentlemen of the jury, my co-counsel, Ryan Kreck.
Thanks, Jeremy. Hi, yes, my name is Ryan Kreck. I've been practicing law now for about 12 years. I do criminal cases and CPS cases. I do a lot of cases. I used to do family law, but I do a lot of cases that involve either CPS investigations or cases that actually lead to CPS trying to remove children from the home, take conservatorship of them. But also there's a lot of overlap with criminal cases, so it's good to have a firm attorney that handles both cases, and so that's kind of what I gravitated to in my practice, and that's what I do.
And it's really interesting. You say you've practiced for 12 years, but that's pretty interesting because you're only 25.
Well, I'm 38, but I appreciate that. But
they were going for
years.
it, just so you know. We pull the wool over the fans' eyes all the time.
Okay.
And I think we were on our way to doing that. So
yeah,
go ahead, keep going.
No,
but there is a lot of intersection between CPS and all those areas that you mentioned: family law, criminal law. Talk a little bit more about that.
Okay. So a lot of times there are a lot of different offenses that could lead to CPS involvement. DWI with a child in the car, things that you wouldn't necessarily think about that would be just like entry to a child case, abandoning and endangering a child. There are other things, domestic violence allegations. Almost all the time, if the child is at home, will lead to a CPS referral. Just CPS sometimes is the starting point that people use to make accusations for divorce, and that turns into criminal or just as a basis to try to get a leverage on custody. But DWI is another one. Domestic violence, those are the main ones. Possession cases. If you have possession in the home and there's a child, they're going to call CPS to see if you are the parents in the house, whether it be a boyfriend, girlfriend situation, spouse situation, will come in to see, are you keeping your kids safe? Are you not exposing them to unnecessary risks? CPS has a broad-ranging implications in a lot of different types of cases.
Let's kind of take this. Let's do the 40,000-foot view here. What is CPS, or who is CPR? Who are they?
Okay, so CPS is what it's actually called in Texas is the Department of Family Protective Services, and CPS is what they're kind of known nationwide as. But it is a collection of investigators and some other individuals, from caseworkers to adoptive services to counselors. They are basically a state entity that is charged with investigating allegations of emotional abuse, physical abuse, sexual abuse, and child neglect. And those are the four areas they get involved in. All of those have sub areas that are very expansive, but they're the ones that, if a referral or a mandatory reporting comes in of an allegation, they'll assign it to an investigator. They'll come to the house where it allegedly takes place, or where the child reside, and kind of follow the investigation.
Does CPS have judges?
No, they do not have any judges. They are not law enforcement. They are a state entity, but they have no special powers to do anything. They just investigate based on referrals. They can make referrals to law enforcement. They can go to a judge as a party like any other party in a lawsuit, whether it be a spouse in a divorce, a parent in a custody case. But they are just another party that could go to court. They don't have any special powers that people think a lot of times, oh, they can just take my kid. Now, there are certain situations where there's an emergency, like a life-threatening situation, an injury that's very grave, usually broken bones in an infant, near death, injuries would lead to CPS making an emergency removal under the family code. But other than that, they don't have any judges or special authority or anything like that.
Is there a bright line as far as ages go that of the children that they deal with?
They deal all the way until the age of 17. Now, there's adult protective services that deals with adult cases, whether it be taking advantage of seniors or other things that maybe a disabled adult where they would come in for medical neglect and things like that. But they deal with children up to the age of consent.
Okay. So let's talk about some of the powers that CPS does have.
Okay.
What can they do unilaterally? What can they do on their own?
On their own, they can make emergency referrals, like we talked about a second ago, for situations that are very dire. Child's in the hospital for injuries, broken bones in an infant at the hospital, maybe a child that almost drowned in a pool, and they don't know if it was intentional neglect, child was abandoned, things like that. If there's no one to, like a child runs away and there's no way to identify who the parents are or ascertain their location, then they can do an emergency removal. That's the power that they have that implicates people and their children. Their power is more of people's fear they have in them. But legally speaking, they don't have any special authority to that. They can make referrals to law enforcement if they think there's a criminal offense that took place. They're usually brought in by law enforcement, so that can go both ways. But powers they have is they're only tasked with investigating allegations of abuse to see if the children are being protected, if they're in a safe environment. And then they can decide then to go to court and try to seek removal with a court order. But those are kind of the parameters they have to operate before it goes further into the process.
Okay. Let's talk about some common scenarios that you see in your practice that kind of come before you. So let's say, for argument's sake, let's take what you were saying about like a DWI with a child.
Okay.
So let's say that there's a DWI with the child, or for instance, maybe domestic assault, or somebody gets arrested in the home and the kids are just present. Mom and dad are fighting, something like that happens, the police come out, make an arrest, and just 9 and 11-year-old kids just are witnessing it all.
Okay.
Talk about how that might look.
Okay. So basically, law enforcement's called in 911 after domestic violence. The police get there. There are children present. If it's on the 911 call, they may make the referral to CPS prior to their arrival. Depending on how long the investigation takes place at the house, CPS will either show up later if somebody's on call and they respond, or they'll come within the next couple days to come talk to the parents that are involved. More than likely, they'll go right to the person that's the alleged complaining or the complaining witness, the alleged victim in the case, and go get their side. And so they kind of investigate to see what the family dynamics are, what happened, how it was exposed. Now, so CPS gets involved in domestic violence cases, and they title it under child neglect. Okay, and their theory on that is basically it's emotional neglect to expose a child to domestic violence. It affects them emotionally. So even if they don't see the assault, CPS will show up. And so a lot of people say, well, they didn't see it. It's like, well, CPS is going to assume that either they heard it, they know what's going on, they can see the tension in mom and dad's face, and so they get involved a lot of times.
What can CPS do in those instances?
Really,
because too, you've got a couple things going on, right? You've got the criminal action, which probably is already happening anyway, right? Because the DWI with the child happens because trooper so and so pulls over mom or dad who's in the car, and then the kid's in the back seat. And for DWI for a child, just so everybody knows, it's under 15 or under.
Right.
Right. So the arrest is already there. The criminal action is already going to be there. CPS is going to come in sort of after the fact.
Correct.
But yeah, what can they do, or what will they try to do?
Well, so what CPS likes to do is they try to get as much information as they can to see what the problems are in the underlying allegation. And so what they're going to, like in a DWI case, they're going to ask questions about how often do you drink? Do you use illegal substances? How often do you do that? Why do you drink? And they're going to assume that anything you tell them is actually a little bit worse than what you're relaying, because sometimes people are trying to preserve them, self-preservation, but they're trained to assume the worst.
So it's relative. So
it's
if
relative.
you tell them, man, I am drunk all day every day,
yeah,
they're going to think you're.
Yeah, they're going to believe you
even
if you really hang yourself out there. It's like if you admit to what they already think is going on, then they'll be like, oh, well, we believe them, But then they're still going to treat you the same way. What they can do from there is they're going to make a finding. So a lot of times we get questions about, what's on my record or something like that. But what CPS does is they make findings in their investigation. So you'll get a letter at the end of the case saying, alleged victim, they'll list all the children, alleged perpetrator, is the parents that are being investigated. So in a domestic violence case, it'd be both parents, and then after that, it's what classification or what.
Even the spouse who's the victim is going to be known as the perpetrator.
Not every time, but yes, possibly they could be a perpetrator. Like especially if it's like a mutual combat or self-defense, and there's obviously some pushing.
That seems fair.
Yeah, and so, then they'll have the group, like the 4 classes of different things that they investigate: physical abuse, sexual abuse, neglect, and then a disposition. And so they have 3 dispositions that they can do they basically either rule. They have 3 dispositions. One is ruled out, basically saying they have nothing to back up the allegation. Unable to determine is basically they have an indication that something took place in a referral. Somebody, either a child or somebody, said, yeah, that's possibly what happened, but they can't back it up in any way. There's no admittance by any party. And then there's a reason to believe. Now, a lot of people are worried about what does reason to believe mean? In the law, it doesn't mean anything, except for that's what CPS has determined inside their records and in their system. It doesn't have any sort of binding effect on your court proceeding in a criminal court, the district attorney's office's determination if a case is legitimate or not, or even the police's determination. That is just based on their policies. We have these things to show that this allegation may have happened, so we find it as reason to believe. It doesn't fit any sort of burden of proof that you have in criminal law or even family law by preponderance of the evidence or anything like that. It's just they believe it happened. Mm-hmm. And that causes a lot of people to kind of worry and stress out about CPS and the power they think that they have.
Okay, so let's take it from there. So let's say we take our DWI with a child or domestic assault case. We have a CPS investigation. They come back and they say reason to believe. What next?
Okay.
Or what impact does that have?
Okay, so there are 2 things. So while the investigation's pending, they could have, to kind of answer your question, what could they do as a result of it? A lot of times CPS will try to get you to sign a safety plan. A safety plan, when I talk to clients, they feel like they're signing a court order. It's not a court order. It's a contract essentially between you and the Department of Family and Protective Services, CPS, basically saying, I agree to do either these services as a result of the allegation.
And when you're talking about like counseling,
yeah, and so,
AA, things like that.
So yeah, to answer your question, the safety plan can lead to services, but they can make you or recommend you do services.
Okay.
So there's 2 routes. There's family-based safety services, which is voluntary. Basically, you agree, yeah, I might have messed up, so you don't want to go to court or escalate. You kind of agree. Say I'll do what services you're asking. They'll assign you to a family-based safety services provider or caseworker, and they'll give you a list of services. They'll usually include them being able to come to your house once a month, interview you, maybe go see you, take a substance abuse evaluation, depending on what the allegation is, counseling, parenting classes, and those sorts of things, depending on what the allegation is. Or if they think it's more serious and they want to see conservatorship, they'll file a petition to try to remove the kids, or a petition to compel you to do services if you don't want to agree to the voluntary things. But it's the same services.
They have to go to a judge to get those things.
Right. And so, like, when people ask me, what can they force me to do? What can they make me do? Technically, they can't make you do anything. I tell all my clients to say, you do not sign a safety plan because that locks you in to whatever that contract is. You can revoke it at any time. but they're going to give you heck about it. The CPS is going to be like, oh, my God, they violated the safety plan. They didn't follow our safety plan. They think that's their silver bullet to coerce you, to leverage you into a position. And so if it's a situation where nothing happened or they're asking way too much or they're assuming a lot worse than things are, safety plan kind of keeps them in your family for a long period of time. Those are good only for 30 days. They have to be renewed every 30 days, but a lot of times they're not. And so a caseworker or investigator will say, well, you're under a safety plan when really you're not. And so they have to go to court in order to compel you to participate in the investigation, which we can talk about, how to interact when they show up at the door later. But they also have to file a petition to force you to do services if you don't want to. And so they have to serve you a petition. It's all under the civil rules of procedure, so you have 20 days to respond with an answer. You're entitled to notice of a hearing, and then they have to justify to court why they think the services are necessary or why they believe these individuals should be compelled to participate in the investigation. And so they have to go to court for all of that.
Is there any good that comes out of cooperating with CPS in these regards and signing a safety plan, or is that something that well, I'll let you talk.
Yeah, so that's a very hard question to give like a specific answer to. It all depends on the referral and your involvement in the case. If this is one spouse did a criminal act and really they're the focus of the investigation and you're the other spouse and you don't want the kids taken out of the house, then yeah, sign the safety plan to say, which will probably include some provision saying that person can't have unsupervised access or any contact at all, and you agree that you won't let that happen. Sometimes doing that will take the potential out that CPS will seek to remove the child from both parents. Sometimes the safety plan is just like, don't use illegal drugs. And it's like, well, that's the law, so there's no harm in signing that. I mean, and so it's really depending on what they're asking you to do and what the allegations are and your involvement in that. Sometimes they'll get like grandparents. Let's say mom and dad have a huge drug problem. They both get arrested for whatever, possession, theft, something like that. And there's indication that CPS thinks that the children are going to go back to them on bond or something like that. They could go to the grandparents and say, we want you to sign a safety plan. And if you're the grandparent in that situation, it may be in your best interest to sign the safety plan so that the child's not taken to foster care or something worse. Sometimes you'll get somebody like a single mom who gets in trouble with DWI and the dad's abusive, hasn't seen the kids in 6 years. And by law, there's no order saying he can't have the children, but he's a deadbeat or whatever. CPS would have to either consider placing him with that dad. And so sometimes it's best to sign a safety plan saying, okay, I'll do this little thing that doesn't jeopardize everything else that you're going through to make sure my kid doesn't go. So it's a really hard question to answer. But if they show up and they're accusing everybody in the house of something, you do not sign anything.
Well, the Lawyer Show podcast is about hard questions.
Yeah.
And difficult answers.
Yeah. That makes sense.
Perfectly.
Okay.
Perfectly. I keep waiting for this to be where's the hard or confusing part about all this. So kind of back to what you're saying. So in criminal cases, so everybody knows, we can one of the main objectives in most criminal cases is to get the case either non-disclosed or expunged, to get it off your record, right? Certain folks obviously come in, and we're doing just we're performing a miracle just to keep them out of prison in some instances, and in capital litigation, not that we're getting off on a different path, but like in capital cases, some of the best work that some lawyers do is keeping somebody off of death row. So victories are relative, but to the point with CPS, these findings that they make, reason to believe, for instance, is there a way to expunge or get rid of that record, and what is the impact of that finding on somebody else's life, irrespective of what happens in the criminal case?
Okay, so to get a reason to believe finding reversed or off your CPS record, okay, so there's like record with expunction, but there's a CPS record. Those two don't intersect for like criminal implications, but like your CPS record, you can file an appeal. It's an administrative appeal inside CPS, basically saying this finding was not in conformity with the policies, or here's evidence to show that they either neglected or didn't know about, to reverse that reason to believe finding. Those are all done internally. There's basically the department does have persons that check work throughout a case, even if it's like a custody case and they're trying to remove your kids. But they have a wing of CPS that's basically kind of like their internal auditors, basically making sure, okay, was this legitimately done? Was this properly done? Were policies followed? And so, yes, there is a way to do that. I have no idea what the success rate on that is broadly, but the 3 or 4 that I've done, recently in the last couple of years, they've always just died. They never go anywhere. If they have any evidence that's going to support the finding and that's just the accusation, they're going to say, well, we have enough to do unable to determine, which are extremely hard to reverse or reason to believe. If they have an allegation and the child says, yeah, what I said before to, let's say, a forensic interviewer, and I say it again, they're going to say, okay, it's a reason to believe. So it's really hard to get those off. Now, the implication of those things on a CPS record, they're not many, but it could affect being approved as a babysitter if you're in that sort of line of work, or daycare, Montessori teachers. Those could affect your ability to get approved for those sort of licensed positions and stuff like that. So there are some implications in those sort of lines of work.
Adopting,
yes, it would affect that. If you ever get in trouble with CPS again, the investigator's going to say, well, you have a CPS record, so this allegation may be more likely to happen again or be true. So it would affect further or subsequent investigations by CPS. There's one thing. It's not so it's not a direct implication from like a finding of reason to believe in like divorces and custody cases, but if it's a domestic violence allegation under the family code, that could be used if you have a incident of domestic violence 3 years prior to the final hearing in your divorce or your custody case. That could disqualify you from being a primary conservator. Could also lead to supervised visits, and that includes taking a deal and getting deferred. It's dismissed. It's not bound by what the result was in criminal court, but if there's a CPS finding, the attorney on that other side in the divorce could use that, get that investigator and whoever else was involved in this criminal investigation to prove this is what was accused of happening. Here's what happened. Here's the injuries. Here's the affidavit on prosecution that may have been filed to show that, well, maybe it did happen, but she didn't want it to go forward, or he didn't want it to go forward. And that would be used to disqualify you for custody purposes.
So a lot of these come in conjunction with family law cases, in conjunction with custody cases.
Right.
Obviously, it goes without saying that some of these reports to CPS, maybe they're true, maybe they're not true, but some of these are strategical things that one parent is kind of rubbing their hands and saying, aha, here's what I'm going to do. Here's this play that I'm going to run. Talk a little bit about that.
It is extremely frustrating in divorces or custody cases, modifications of custody, where you get an affidavit, there's a restraining order saying you can't see your kids, you get served by a process server or constable, and then you find the affidavit on there saying my child said this, and then CPS shows up within 24 hours. That could be sexual assault allegations, just weird behavior. It doesn't even have to be a criminal offense. It's just inappropriate behavior that they believe could be damaging to the emotional development or the safety of the child. And that could range from, I see daddy drink a lot, and that's all the child says. But
daddy listens
my goodness.
to Marilyn Manson
in
front of me. I don't know how much of our audience would even. Do you remember? You remember Marilyn Manson?
I know Marilyn Manson.
You're only 25. So Ryan has a very rare. He's got a full head of hair, which is it's a subject of.
I'm blessed in that department. My dad's 72, and he still has a full head of hair. I think he's gone up a little bit. So man. I'm hoping that rings true for me too. Sorry, Jeremy.
Look, man. I mean, this is. I'm doing the best with what I have. Heidi complimented your hair on the way up here today.
Hair gene is passed down from your mother's father. So if your mother's father has hair, you have hair.
If you couldn't hear that,
my faith is misplaced then, or my hopes.
Because Heidi's off mic today. Not that we don't trust her after we've had her on the microphone before, but Heidi has indicated that your hair gene comes from your mother's father. And by the time my mother's father was in his 70s, it was gone.
Yeah.
But I saw pictures of him during the war, and he had it when he needed it, as did I. So now that I'm on the, whatever. But this has been the most fascinating part of our whole talk, really.
Well,
So back to CPS.
Was that a hit on me? No, I'm just kidding.
No,
I'm
man,
kidding.
We're drinking from a fire hose today, man.
Yeah.
I mean, most of the time on the Lawyer Show podcast, it's shtick city because, I mean, part of it's because I'm constantly steering the thing in the ditch.
Yeah.
So anyway, back to the CPS stuff. Okay. So what let's talk a little bit about kind of what we fear as criminal lawyers when we hear that there has been a CPS referral. We don't want that. Sometimes CPS cases and CPS referrals for us, and you're the main guy in our office. Anytime the words CPS are mentioned, the first thing I do is I pick up the little thing where I shout down the hallway and see if you're there. So a lot of times CPS is just kind of a CPS issue is sort of just a monkey on your back. It comes with, like we were talking about, the DWI with the child or or domestic assault, which the arrest has already happened, the criminal case is already happening, and here comes CPS to make things even more fun for everybody.
Right.
But what we fear is when a client comes in the door and says CPS is investigating X, Y, or Z. We're afraid that the reverse is going to happen, that whatever CPS is investigating turns into a criminal charge. Talk a little bit about how that works with CPS and some of those issues.
Okay, so yes, anything you say to a CPS worker is not protected by Miranda, Fifth Amendment, anything like that. They can testify about anything you said to them in the course of their investigation. They don't have any special privileges like to talk about hearsay, from other witnesses, but in court. But anything you say to them can be used eventually to be referred to law enforcement, to the district attorney's office. They can make referrals directly to the prosecutor if they know there's one involved, and it's a source of discovery that as a criminal defense attorney we need to know about for sure. But as a person being investigated, I always advise my clients or anybody in our firm, saying you do not talk to them unless we agree to a meeting. It's at our office. I'm there. Your attorney's there. One of us, if I'm not there, and it's very controlled and limited. You don't have to answer any of their questions, but to get to the question, it can anything they hear they can refer on, be it an email, be it a report that they issue in their records in CPS. Call up the detective, text them, email. I've seen it all where they just kind of pass it along, and then the investigator, prosecutor, whoever's involved will decide, is that worth following up? CPS investigators, just while we're on it, are not detectives. They're not peace officers. They don't have any special training with law enforcement. They're only trained by CPS based on what they want their investigators to do. So they're not experts in the law. They're not experts in investigations. And so sometimes they mishandle investigations, which is kind of advantageous to us too sometimes.
And they're not here to defend themselves, Kreck, which means that we really need to go after them.
What do you mean?
Oh, criticize.
Oh, well, so CPS workers, their intentions from their point of view are good, and they believe they're doing the right thing. And a lot of times, not a lot of times, there are times where they should be involved in a situation. It got out of hand. Young parents messed up, or whatever the scenario needs to be. Is the cases we see most of where it's like gray area. It's like, well, why are you really involved? Why are you making more out of it than it is? And it's hard to not be so cynical of them in that moment when they're trying to do their best based on what they're getting, and people are telling them conflicting things. One parent's posturing against another. So it's a very impossible job sometimes to be fair and right all the time, most of the time, whatever you want to say. But it can lead to those investigators and caseworkers really pushing something to law enforcement that they think should be pursued. Law enforcement sometimes is kind of worried about how it all unfolded, and so sometimes they have to redo the work or double check the work from the CPS, which is the right thing to do. And so that's how it just kind of flows to law enforcement, however the caseworker wants to do when they're associated with a case.
Some people may assume that if CPS is involved with something that it's necessarily going to be criminal, but that's not always the case.
Right. Most of my cases where I get involved as I'm just helping out a client with an investigation never leads to a criminal offense.
That's just because Ryan Kreck's involved.
Yeah. But I mean, there are a lot of improper punishment. It never raises to an injury to a child, but maybe it was excessive. I mean, that's never going to be a criminal offense. Child runs away, child mental health issues. How do we treat it? How do we deal with it? Those are not going to lead to criminal offenses, but sometimes parents don't handle it appropriately with what knowledge they have of mental health services and treatment. And then they have an outburst at school, and then they're like, well, what are the parents doing about it? Maybe nothing, maybe not enough. And CPS has a difference of opinion. But a lot of times they do not lead to criminal offenses. There are a lot of just parenting-related referrals. And some of them, a lot of these kind of die on their own. A referral will be made by a nosy neighbor who says, that kid's screaming a lot. You just don't know if you have a kid that has, an emotional disability or a mental disability and they're just loud. Maybe they are worried, maybe they're scared of mom and dad because they're being excessive. But there's a whole gambit of referrals that would never lead to a criminal offense that just involves parenting decisions and caring for children in a certain way.
What is a mandatory referral?
Okay. So a mandatory reporting, mandatory referral under the law is basically teachers, counselors, law enforcement, not anybody that hears an allegation of domestic or child abuse, but even lawyers, if they hear child abuse is happening, have to mandatory report to CPS. And those are situations by law where even an allegation's made, even if the person doesn't believe it, like a teacher hears a student say, hey, my uncle, did X, Y, and Z, they have to report it even though they may not even think it's true. But the mandatory reporting statute is those referrals have to be made to CPS, then that will lead to CPS investigating those allegations.
And that's a common fact pattern that we see a lot in our office, and you can kind of see it unfolding.
Right.
Kid goes to school, kid says this in front of the teacher, or kid goes to counseling, says something to the counselor, and the counselor may, like you were saying, the counselor may believe it, the counselor may not believe it, but it's essentially that teacher, that counselor's license on the line.
Right.
If they look the other way and they plug their ears.
Yeah.
So talk a little bit about that part of it.
Okay. So yes, they could lose. They can have a disciplinary action on their license if they don't report as they're supposed to. Like I said, they don't have to believe anything if the allegation is true or not. And a lot of times, these entities or individuals are trained that they have to show belief to support the child, so that child doesn't have an emotional hit on them to where they're not felt believed. Like they feel like they're coming forward, they're disclosing something. So the person that receives the mandatory reporting are usually trained to kind of get them to not open up, not to do an interview, but to say, hey, this is a safe environment. Clearly explain what you're talking about, or we'll see what we can do, stuff like that. And so it kind of creates a weird situation for a reporter where if they don't believe it, they're kind of feigning belief, but in order to support the child while this disclosure is coming out. It's a hard situation for reporters to be in sometimes, but they know they have to do it. The law says you have to do it. You can lose your license, your livelihood, your job if you don't report it. And it's not their job to investigate, so
Sure.
always report.
So it's a really, really. I've always kind of thought it's a really tricky pickle for a lot of the mandatory reporters for different reasons. And in some ways, I don't know that it hurts more than it helps. I mean, we didn't write the law,
Right.
but what you want to have is you want to be able to, in a perfect world. I mean, in a perfect world, you would have no child abuse.
Right.
Right. You would have no abuse. You would have no neglect. But a reporter, like a counselor, like a therapist, these are a lot of times paying customers. These are customers who come in and they like you. They like you because you listen, because everybody feels better when the kids and the mom and dad are at the therapist's place, and everybody goes home with warm and fuzzies. And then then the reporter at the same time also wants everybody to feel to be open with her or him and to say, okay, this is a place of safety. It's a place of freedom. It's a place where everybody can kind of get things off their chest. But I got to tell you, if you're going to tell me something that sounds like this, that, and chicken fat, I'm going to have to pick up the phone and call CPS, which kind of puts a block in some ways. It's an obstacle.
It does.
That between the patient and the provider.
Well, it's also kind of like, regular cases for us too. Like we have, let's say, a 20-year-old get arrested for something. Mom and dad are footing the bill. Child wants to tell us something, but because of confidentiality, we can't tell mom and dad. But they feel like they're entitled because they paid the bill. That they're entitled to all the information. It does create that sort of block to where it's hard for us, and in this scenario, the mandatory reporter to retain the rapport with the family for the legitimate purposes of therapy, family reunification, working on just whatever's going on. It is a very hard situation for mandatory reporters sometimes in those situations.
In particular with our clients, it's even more confounding or more difficult because our clients pay really, really high fees on time. And if they don't, Debbie in our office gives them a very nasty call. By the way, I need to also I'm told that Irma is watching the show today. Irma works at our office. I quiz her every time I get back at the office what was her favorite part of the podcast, and I get very suspicious answers from her. I get very vague details.
I like when you talk about the law.
Makes me think that she's not actually watching.
Yeah.
I did give Debbie a shout out, and here's another shout out to Debbie. Heidi said that. You're welcome, Debbie. We love you. We couldn't do any of this without you. We love everybody at our office. But yes, you're correct too, because when we're mandatory reporters in a way, and what we have to do is we have to structure our questions because people are coming to us wanting to hire us for our services. We put a lot of resources, as does any lawyer, into getting the phone to ring, but then we have to kind of say, but it's really hard to do that. And sometimes too, I'll tell you, and not to get too off the track here, but I think this is all sort of germane. A lot of times too, we work with a lot of licensed sex offender treatment providers.
Right.
We also have a lot of dealings with Collin County's probation department.
Yeah.
And they have specific individuals who deal with sexually oriented offenses and cases. And they approach a lot of their caseload as we're here to help you. We are here to help rehabilitate this person.
Right.
As would be the provider. And so it's hard for them to treat when they're constantly having to do this, right? Because if you tell me that you've done this, I've got to go pick up the phone and call CPS. So what we find is that they are really, really good at structuring questions to say, okay, Joe Blow, don't tell me names, don't tell me addresses, don't tell me dates, but has something that sounds like this ever happened. So they can try to do that, so they can try to treat, right, but not at the same time not have to call the cops on the person that they're trying to in some ways help.
Oh, yeah, totally. And that even applies to like drug cases. If you go to treatment as part of your probation, you're in a group class and they want you to be forthcoming about your issues. And so if you're relapsing, if the class leader doesn't like you, that can lead to a revocation, even though you're saying I messed up, I relapsed, and so that's an admission of use while on probation. They use that to revoke you, but it's a spirit of or an environment of, being forthcoming so you can work on those issues, and that applies to like the sex offender case like you talked about all the time. It's kind of like, well, he admitted something that went a little too far, so we'll revoke him. Versus,
we didn't know you did that.
Yeah, it's like, whoa.
We wanted you to be honest. We didn't want you to be honest.
Yeah, exactly.
So that's kind of what the pickle that they're in.
And so it's damned if you do, damned if you don't, from the perspective of our client.
This is a PG-13 show, Kreck. Yeah. You just said, no, you said, I caught very early in the program, you said the word heck.
I did.
And I was going to correct you and say that the proper word is hell.
Well, yeah.
Okay. And but then you just throw out damn. I mean, this is just, we're having a lot more fun here than either of us thought we would today.
Yeah.
With CPS and the mandatory referrals that happen, a lot of those are going to be dead bang. The police are coming.
Right.
Talk about some of those situations.
So the referral will go to CPS if it's a child abuse, sexual abuse claim, or the sexual abuse. Let's just focus on that. Then law enforcement will be immediately called as well, and then they might actually make a joint approach, where CPS and law enforcement shows up at the door. That's obviously a scary situation for anybody, but both of them showing up happens in other cases too. They're not mandatory reporters, where a police officer's nearby. Like if there's an allegation of assault and they're worried the perpetrator's there, so the CPS worker can do what's called a civil standby, where the police officer will be there for protection for the CPS worker. Sometimes it turns into a situation where the police say, "Hey, I want to come in the house, but if you don't want to let me in the house, why don't you let her or him or her from CPS come in the house?" And so it's kind of sometimes a tactic used when they approach you at the door to try to get at least the CPS worker in there. And so if you have paraphernalia, alcohol, house is not clean, things like that, they're going to make note of all that to show, oh my gosh, there's a lot going on here where this child's not safe, stuff like that. Mm-hmm. But yes, they can both show up, and just it goes from there. The investigation can be kind of a tandem to where CPS and law enforcement are asking different witnesses different questions. And that's obviously something to be cognizant about, because all of that can be used against you, whether it be family court, the CPS hearing, if they try to take the kids, or the criminal case if it comes into one.
Mm-hmm. And a lot of times for us, and for you, I mean, sometimes CPS is just kind of, you just kind of have to say, look, we're just going to have to take our lumps from those guys, because we're so concerned about the criminal aspect here,
right?
That they're going to do a bunch of things, we're not going to like it, but we're a little more worried about the bigger picture.
Yeah, of course. And so whenever I'm involved, whether it be like a criminal case in our firm, my case that I have both of them on, or even if other lawyers call saying, "Hey, I have a CPS issue, can you help me navigate that in conjunction with my criminal case?" And that happens sometimes. Or family law attorneys will call us and say, "Hey, can you help us with CPS?" And basically we try to come up with a strategy that's harmonious with both what's happening in that case and this case. There are times where you can walk through the raindrops and handle the investigation with CPS to where you kind of put that issue to bed, but also not jeopardize any defenses or issues you have on the criminal case. That's obviously a case-by-case basis, but that is possible to where you can kind of maneuver both to where you kind of work with CPS to show, okay, here's like an assault case. Mm-hmm. Police officers show up, they're going to arrest somebody. We know that. There's an injury. One side said, but either both sides say that they got struck by the other person. This person's injured more, so they arrest the other person. CPS comes in whenever they get to it. In a non-emergency, they could be like a week later, and they could have a difference of opinion. And sometimes it helps us negotiate or leverage that with the prosecutor if the case gets filed to say, "Hey, look, CPS actually ruled this out. They kind of think, she did it. Maybe you want to talk to them, and that'll help you get that conditional dismissal, reduction, deferred, whatever that ends up being." Sometimes CPS can hurt your case, but sometimes it can help your case, from a lawyer's point of view, or the client's. So, but you just don't just spill everything to the CPS either. You got to carefully do it so you're not jeopardizing one in favor of the other. Sometimes getting your kids back is different than getting yourself on the hook for a conviction, probation, or something later that has, under family violence law, long implications afterwards.
And there are instances too, I think you were referring to, where CPS, where your client and the family are in good graces with CPS, but you've got a prosecutor who is still kind of wanting to bring the thunder and the lightning. You can sort of not, I don't want to say play them against each other, but you can kind of say, well, look here, CPS likes the guy.
Right. Yeah, definitely. And that can, a lot of times it plays out, maybe that leads to a favorable ruling or agreement in the family law case. And so both those two things can then hopefully convince the prosecutor, maybe their first initial reading of the situation, their first impression of our client is overstated, not accurate, whatever. But those are things that collaterally you can use in negotiation purposes, posturing purposes in a criminal case. And that goes both ways. If it leads to a dismissal in a criminal case, then you take that to the family law attorney, and they use that to try and negotiate either with the other side or with the court to say, look, this thing disappeared and there's a reason, judge. That's a long discussion because there's different burdens of proof and other things like that in family law court about whether or not domestic violence took place. But all these things kind of intersect, and they can be used in different ways for getting a result or getting something thrown out, whatever the approach is on the case.
Is CPS understaffed?
I would say yes. There are times where there's a lot of turnover. People are either there for, it seems like, maybe months, or they're there for 5 years, and there's some people that they go all the way to retirement on it, but it's very few. It's a hard job. They're not paid enough for what they do, and so like I said earlier, it's an impossible job sometimes. The investigators sometimes see the worst injuries that children, infants, babies ever experience or go through. And so it's emotionally hard. It's very strenuous on them as well. The cases that are bad, where CPS definitely needs to be involved, and maybe removal and termination of parental rights, there are some cases that are just impossible, from fetal alcohol syndrome to where that child's going to be impaired the rest of their life. There's a lot of staffing issues. They have a hard time bringing in people. Like, one of the big knocks on some people that some people say, especially parents, it's frustrating sometimes when you have like somebody brand new out of college who has a social work degree, maybe counseling or youth, some major like that. They're doing their best. They're trained by CPS to do their best, but maybe they don't have children. So it's the parents are like, well, they don't know what we're going through because they don't have their own children. Not that they have to have their own children to do their job, but it is kind of a frustrating thing to be the parent going through investigation, and you feel like they are not treating you fairly. But yeah, understaffed. A lot. There are times where they have to bring in people from other counties. They usually try to stay in their own county, so there'll be like a Grayson County office, a Denton County office, and you'll see people from those offices brought in when there's understaffing, maternity leave, if somebody's on a case and they need to assign somebody, or there's a conflict of interest, because there's times where CPS workers are investigated for these allegations, or attorneys or somebody that, like if an attorney who does CPS cases is investigated, they usually bring in somebody from another county. So it's not like, well, I treated this person poorly.
This guy yelled at me a bunch of times.
This guy had me thrown out of court, or all my testimony thrown out, so therefore I got my time to get him now, or whatever. So there's a lot of staffing issues, and sometimes they bring in people from other counties.
What is the most common mistake that you find people make with regards to CPS? Non-lawyers, just regular humans.
It's in my opinion, it's signing that safety plan that it was asking for way too much, very restrictive, or voluntarily placing your child with a relative. The safety plan just locks you in some level to a long time of CPS involvement. It's not knowing your rights. It's those two things lead to a lot of situations where they come to us after the fact saying, I thought I was doing the right thing. I was doing this, like we talked about with the reporters, where you're trying to be, here's some information. Yeah, maybe I didn't handle this situation right. So then they take that to say, okay, you're not making good parenting decisions. We need to be more involved. It's like, well, no, this is a one-time thing. But now they think I'm this horrible parent for the last X number of years of my child's life, and so now I have to do all these services that I don't really need. And so those are the two things that lead down a path of CPS really being in your life, and you feel like they don't need to be.
And sometimes people can feel like they have to. They can
Right.
feel like they don't have a choice, or just things just get worse if they don't. We're all, to some degree, programmed to respect authority.
Correct.
For better or worse.
Right. And I think it's amplified with CPS because just the threat, everybody knows CPS can take your kids, but they're confused about how they do it. Do they have to get a court order to do it or not? But that fear of, I can lose my kids tonight if I don't say the right thing, leads to people to either share something that they shouldn't have shared or didn't need to share, or it goes to a criminal allegation. They're kind of like, yeah, I hit her, but then there's no context to, oh, wait, I was defending myself because she hit me first. They put down, oh, he admitted to hitting. But there's no context. There's no anything that would show that's not a criminal act in of itself because it was justified defense. And so not knowing what your rights are with CPS is a recipe for sometimes them to be involved in your life for a long time.
What would you say is a common mistake that lawyers make with CPS that maybe do practice in this area, maybe don't practice in this area? What are some common mistakes you see there? And we can name names.
Right. I like to think I haven't made any of these mistakes, so maybe it's a little hard for me to jump right to something. I'm trying to think of something.
Because sometimes we'll be getting brought into cases where the client's not confident in the lawyer that they've had.
Yeah.
Maybe that lawyer has made some missteps or done some things that make the client a little uncomfortable.
I would say there are times in like CPS cases where they've filed a petition to say, hey, we want to take your children out of your house for a period of time. In those situations where there's more back and forth with a CPS caseworker, they're kind of like the representative for the department in a case. They are the caseworker that would deal with the parents on a daily basis, but I've seen lawyers kind of make admissions of things that were maybe confidential or put their client as being culpable on a criminal allegation that may have been on the side.
Should they do lawyers ever say, do they ever cooperate when they shouldn't?
Yeah, no, there are definitely times. Sometimes, like good CPS workers that have done it a while will kind of, play rope-a-dope a little bit and talk to the lawyer for one parent that they believe they're kind of been cleared. Like if it's, really the primary aggressor wasn't arrested in an assault case and they get him kind of opening up, talking, and then they kind of make statements. Oh, well, my client made it, hit him too that night, and they didn't know that. There are times where that kind of leads to a little spark of information that they can come back when they think they're kind of on the hook for like, oh, we're going to get the kids back. Really the other one was the aggressor, and then they kind of slip up on something. But, yeah, it's usually making little mistakes of slipping up information that, you think is helpful to getting your client's kids back, but may have also put them on the hook for either clearing somebody. Like if it's a divorce situation and you're trying to frame your spouse, saying he abused me and did all this stuff, it could undermine your position on that. If you make too many statements, if you're trying to get the kid back by undermining.
What is the proper way to frame your spouse with a CPS?
Well, see, that's
with a
CPS
investigation, because I think people are taking notes at home on this.
Yeah, no, it's funny because like sometimes we'll have a case and we tell a prosecutor, well, she's framing my client, and it's like, well, how prove that? It's like, well, if you're doing it right, you shouldn't be able to prove. You should be able to prove that you're being framed.
That's right.
And so when a prosecutor asks, hey, okay, show me that he's framing her or him or whatever. If they're doing it right, you can't do that.
See, that's kind of so we get in just criminal law. We get this every once in a while. It used to just be maddening to me. Some really experienced prosecutors during jury selection used to make the argument that was, look, this defendant, the criminal, chose the time, the place, the victim, everything. So that's why there's no evidence of this, which is it's a terrifying argument because in some instances, I suppose it can be true.
Right.
But it's basically saying the fact that there's no evidence is proof of guilt, which is exactly the opposite of
how
the
the law
presumption
works.
of innocence and how the law ought to work.
Yes.
And it's terrifying because jurors are sitting there going, yeah, that's right.
Yeah.
So what you're saying is, look, I can't prove we're being framed because she did such a good job of it.
Right. Like I can't prove how that little baggie of white stuff got under my passenger seat of my car. I've never done it, but she did in college. But it's like, oh, of course you would say that, And then you're like, okay, but how do I prove that she actually put it there? They never test fingerprints unless it's a murder, or something very similar.
It's kind of these push-pull arguments that we get into all the time where there's no right way to say, look, I mean, the guy, why is the guy, the guy is so nice because that's how he lures everybody in because he's so nice. Well, no, how about he's nice?
Yeah.
How about there's nice people running around?
Yeah,
running around America.
Like an argument I've made recently in a couple of cases on like sexual assault cases is they talk about grooming. It's like, well, grooming is only grooming if there's an allegation. Like otherwise, it's called being a generous grandparent or something like that. You're buying gifts for presents, at Christmas. Is that grooming? It's kind of like you said, the absence of evidence sometimes is evidence, and that creates a situation where jurors could go, okay, I understand that. Okay, maybe something did happen.
By the way, and everybody on the podcast audience needs to know that this whole podcast exists my ego, for my self-aggrandization, for me to just talk about me, which is my favorite topic. And so I will very rarely give anybody else credit for things, much less more credit than I deserve. Ryan Kreck in our law firm has gotten probably 2 of the most titanic not guilty verdicts since we have had a law firm. He has acquitted people in 2 cases in a row.
Continuous sexual assault.
Continuous sexual abuse of a child, which carries with it 25 years to life, day-for-day sentences. He has 2 not guilties in a row in that area. So he is. Yeah. So I'm still not saying that you're better than me.
Yeah.
but Krecky here and Kreck also leads our law firm in nicknames, because this is the name Kreck. It lends itself to so many. There's the Krecken.
Yeah.
Right.
That's one of your favorites. Yeah.
That was from Kyle.
That's true.
He dubbed you. I like it.
Yeah.
There's Krecken. There's Kreckman. Right. When
that's when you put it on there.
That's when I'll throw that on there. My favorite is Kreck Nasty. But we just Kreckmeister. That's Heidi's. I haven't. I heard. So these are all terms of severe names. I put out a text to the other lawyers in our office, and I asked for any zinger questions I can ask you.
Yeah.
I'm really wishing I didn't send that text out.
Okay.
None of them are particularly
helpful or constructive or PG-13.
None of them are really PG-13, and it's even sort of turned into nobody's watching this anyway, so it doesn't matter who you offend. So
yeah.
Thank you, Bo Calibus. I'm sure you're not watching either. So, okay. If there is one thing that everybody watching ought to take away about CPS, what should it be?
CPS, while the organization has good intentions and they have a good legitimate purpose, when it comes to from your perspective as a parent and they're at your door, do not think that this cannot get out of control. Do not think that it doesn't matter what the allegation is. It could lead to just emotional stress, depression, anxiety for the next 6 months of your life, 1 month at a minimum. They have a lot of perceived power. I say perceived because the law says they can't do anything without a court order in almost every situation, but they have that badge of protecting children, so therefore what they say goes. They have the politics behind them on the sides of it's very hard to convince a judge that on a case where it's a coin flip on the evidence to say that they're wrong. Mm-hmm. There's going to be a lot of deference given to them. So at that door when they show up, not appreciating the situation is the worst thing you can do.
You think people think that I got this?
Yeah.
I sell cars for a living. I am the head of my accounting section. I can talk my way out of this.
Right. People think they can. But the default position of CPS investigators is they're trained to assume the worst. From their perspective, they think that's more protective of kids, saying we'd rather be more involved to protect children we think that we may not be able to prove are being abused or, whatever. But that brings in a lot of people that come to see us to say, I don't know why they're bothering me. I don't know why I said this one thing and now they think I'm the monster. They think I'm a horrible parent. They want to do this. They want to do that. It can definitely get out of, it's like wildfire. It can just spread very quickly. And so knowing what you can do and not do with CPS, for example, you can record them. I've had cases where I had a client record a CPS investigator in the CPS office up in Grayson County, and then she testified on the stand about this, and this, and it was completely inaccurate. She perjured herself. But she's never going to get prosecuted because it's not politically savvy for CPS workers to be prosecuted for perjury. So when I cross-examined her, she looked at the judge and said, can he record me? She didn't even know the law on that. And the law is, yes, you can record anything you want in personal interactions. And so protect yourself. Record.
You can't record. And so what you just said, just so everybody understands, you can't record other people. You can only record conversations you're a part of.
Right, exactly.
In Texas.
Exactly, yes.
And if you're recording somebody in another state, you're probably breaking some kind of federal
law. But in
law.
Texas, when you can put a phone on in your pocket and leave it on record when you talk to CPS, and that will save you a lot of times because they're not recording. They make notes after the fact. They try to do their best to memorize everything, and sometimes it gets out of hand. Sometimes they Roger Clemens misremember something. But
how many times have you recorded me, Kreck? Or
you?
I'm probably not
Never.
important enough.
Never.
That's what I thought. I'm not.
Because I assume you're recording me.
Interesting. Oh, we got to wrap it up. Okay, this has been another extremely successful episode of the Lawyer Show podcast. We will see everybody again at 12 o'clock next Thursday, unless we don't.